Hi everyone, you're watching the Virtual Amicus and I'm Jay Ludha. So today's topic for discussion would be on alternative dispute resolution in India. So we've today organized a very special Q&A session on alternative dispute resolution. Now, quite recently, the Honorable Chief Justice of India, Justice N.V. Ramanna, expressed his belief and also spoke about the importance in the role of mediation as dispute resolution mechanism, encouraging law students and learn the skills. Now, the Chief Justice also spoke about the importance of having an enactment or a statute that would make mediation mandatory before litigation, citing the backlog of 3 crore cases in the country's courts and also the rising costs of litigation. Now, during mediation, a neutral mediator tries to persuade the two warring parties to resolve their dispute, and instead of parties opting for the other mode of rushing to the court. Now, there are several legislations like the Industrial Dispute Act of 1947 or the amended Consumer Protection Act of 2019, the amended Companies Act of 2013 that provide for a mandatory mediation. Even quite recently, we had the Commercial Courts Act of 2015, as well as the Real Estate Regulatory and Development Act of 2016 that incorporated provisions relating to compulsory pre-litigation mediation. So to elaborate further, today we decided to seek assistance from someone who needs absolutely no introduction, Ms. Nadiya Sarguroh. She is a senior associate at NZM Legal LLP. She joins us from Mumbai. So thank you so much, ma'am, for taking out time on a Saturday. And just to give you all viewers a brief introduction about ma'am, Ms. Nadiya Sarguroh is a senior associate at MZM Legal and specializes in handling dispute resolution, insolvency, restructuring, telecommunications, media and technology, and corporate litigation cases. Ma'am has also tremendous experience in the field of dispute resolution, insolvency and restructuring, regulatory advice, and regularly advises and represents corporate conglomerates on complex matters. She has also been a part of India's biggest media entertainment and intellectual property rights cases. At MZM Legal, she has added a tremendous value to the dispute resolution practice, focusing on international commercial arbitrations. With her experience and innovative way of handling complicated disputes, she also played a key role in handling high-profile restructuring insolvency cases, where she represented many big corporates, financial institutions. She has advised various conglomerates, corporations, corporate secretarial and regulatory aspects, and also defended them before SEBI and various courts. She has regular appearances before high courts, NCLTs, tribunals, quasi-judicial bodies, and other regulatory authorities in both domestic and cross-border litigations. She's obtained a master's degree in intellectual property rights and holds a postgraduate diploma in alternate dispute resolution from the University of Mumbai. And she's also been as a visiting faculty to a number of many esteemed colleges. She has experience of over 5 years in teaching subjects such as alternate dispute resolution, advertising laws, business laws, industrial laws, intellectual property laws at various reputed colleges. And she's also frequently invited as guest speaker for seminars and judging law competitions due to her expertise. So thank you so much, ma'am. Well, the list of achievements and accomplishments is too long, so we had to cut it short, keeping in mind the time constraint and the format of the show. So thank you so much for. So we actually ruined your Saturday evening, but it's definitely worth.
It's my pleasure, Jay. In fact, I really love this idea, this setup of knowledge sharing, where you've termed all of us as virtual amicuses for people who are watching and wanting to gain knowledge. Thank you for the rather gracious introduction. And yes, I do agree. It was quite long. You should have just two sentences would have been enough with my name and my designation at my firm. So yes, today we are going to look into the practical insights of alternate dispute resolution mechanism, and you may proceed to start your questioning.
Yes, ma'am. So let's quickly proceed with our Q&A session. If you're ready,
Yes.
ma'am, we can start immediately.
Absolutely.
All right, ma'am. So here goes the first question. What are the different kinds or types of alternative dispute resolution in India? If you could elaborate.
Yeah. So the basic dispute resolution mechanisms, alternate dispute resolution mechanisms in India stem from the first part, which is negotiation, then there is mediation, then there is conciliation, then there is arbitration, and at the helm of it, what stitches all together is good client counseling. So these become the five fingers basically of alternate dispute resolution mechanism, which are very, very important in terms of taking the backlog out in today's judicial system as it exists in India. Like you rightly mentioned at the start of this session, that the Chief Justice of India today has taken keen interest at the situation of the pending cases in India. In fact, recently the national judicial data with respect to the pending cases has increased to 4.4 crore pending cases all across India over different courts, including the high courts, the district courts, the Supreme Court of India, wherein there are 4.4 crore pending litigations. And this is an escalation to the last year's data, where the status was of 3.8 crore cases. Today we are at 4.4 crore cases. There is a 19% escalation from the last year. So if you see, cases are only on the rise. People in India are of a litigious nature, and there is something which has to break the chain of this vicious system of going into litigation. And alternate dispute resolution mechanism is one such system which could take away the burden from the courts who are dealing with such high number of cases. And in fact, the highest number of cases pending is before the district courts, which is around 38 million cases that are there before the district courts themselves. So the burden is a lot, judges are less, and therefore the system is only being thrashed with more and more cases every year. And that's why the keen interest, because the stats are really glaring in the face of it. And there's an old proverb saying, justice delayed is justice denied. Everybody's fate today in the justice system is just withering away. And therefore, these mechanisms really play an important role to break this chain of litigation and entrust people with better ways of dispute resolution mechanism, maybe through members who have or are associated with the judicial system, who could sit over and take one of the alternate dispute resolutions to resolve your cases. So let's just jump into the basics of what are the different mechanisms. So starting with negotiation, negotiation is inter-party negotiation between the clients and, if required, the lawyers, who sit across the table and want to find out a way where both people can compromise, rather than going into a litigious affair where both people would have to spend in court fees, in the jargons of filing, in spending on lawyers, spending on counsels who would appear and litigate the matter. And if they feel that sitting across, putting across terms and losing a little on each side would actually help them reach to a situation where they are actually gaining out of the entire discussion. So negotiation is a face-to-face talk between two clients where they put in their terms. You may have lawyers who advise you, but better have lawyers who are working in the interest of the negotiation being successful. And many a times clients really don't want lawyers to be there for their negotiations. The reason being that it then gets into a me versus you or we versus us situation, and at the end there is no negotiation that is fairly possible between the parties. So lawyers play a very important role in creating an awareness of alternate dispute resolution, where you can prevail over your, have a better counsel over your clients, telling them that it is better to negotiate and get something rather than going into a litigious affair and spending years over gaining the same thing that you might have got over with 3 years ago or 4 years ago. So that's about how negotiation works. When we come to a step forward in a more professional manner, we go ahead to something called as mediation. And of course, the awareness about mediation today is escalating at a rapid fire speed. Like you said, that more and more statutes are coming up and inserting provisions of a mandatory pre-litigation mediation. Of course, we'll sort of elaborate on it a little later. I don't want to cut into the statutes right now because I'm talking about the basics. So mediation would be where you have a facilitator, you have a mediator who would come up and facilitate both the parties to sort of resolve and compromise in an efficacious manner, where both parties want to put their terms. And if there is a deadlock, the mediator acts as a facilitator in providing solutions to have better negotiations, where it can be mediated and channelized through a manner which is efficient and through a manner which is going to be beneficial for both parties. Therefore, mediation is something which is facilitated through a third party who usually has to be a trained professional. It is always better to have a trained mediator. It is better to have a mediator which is aware of basic commercial laws, who can provide solutions. So if you have a mediator who is not trained, the mediator will not be able to facilitate the session adequately, and therefore the result of the mediation is going to be a failure. Because if two parties are sitting, there are emotions which are going to flow with the case that they have, with the history that they have, and to channelize those emotions into solutions, you need a trained person. So mediation is all about channelizing emotions into solutions through a facilitator who can come ahead and tell you, look here, you want to go west, he wants to go to the east, let us come and meet in the north and figure out this path. And that's where you require a trained professional to be there, who plays the role of a mediator, facilitating two people with a history of the dispute. They might be having n number of emotions, they might be having vengeance, they might be having disbelief, they might be having deceit in them. So many things that would come up on a table when two parties sit together with a history of bad taste. Maybe they don't want to at the start mediate the matter out. So to channelize these emotions, if you don't have a trained professional, the entire session is going to be a waste. So either you go to institutional mediation, where there are mediation centers, where there are empaneled mediators. And in fact, the Consumer Protection Act into 2019 in its rules has said that you have to go only to these empaneled mediators. You can't go to any other third person and get them as a mediator. The reason being that people have got bad history of having bad mediators, and therefore they don't have justice, or they don't have that faith that is there in an efficient alternate dispute resolution through mediation. So your mediator has got to be trained, he's got to be well versed, he's got to be quick, spontaneous. To be an efficient mediator, you have to be on your heels, and you need to know your laws, because every dispute that comes on the table will involve different legislations that are there. And so you need to have trained mediators who are quick in solutions and who are quick in responding. So that's something how mediation works. Now, going to conciliation. So, conciliation basically and usually does not happen on a face to face basis. It is usually when a matter is through a statute. So, conciliation usually comes either under the Arbitration and Conciliation Act 1996, where there are provisions where you want to go into conciliation by a conciliation agreement, where parties want to have a conciliator sit and adjudicate the matter and go ahead again and facilitate the ends of two parties. Or it is some other statute such as your Industrial Disputes Act. Now, Industrial Disputes Act has got a wide variety of different conciliation proceedings that goes on. It goes on before the board of conciliators, it goes on before the works committee, it goes on before conciliation officers who are specifically appointed by the central government to look into the workers' disputes, to look into the industrial disputes that are there between the employer and the employees, and specific set of these industrial disputes between categories that are specified under the Industrial Disputes Act. So conciliation in a way is a statutory mediation for me. I mean, if I had to phrase a difference between mediation and conciliation, I could only say that conciliation would give one step ahead to a mediator, where a conciliator can then make a reference to the court that since the conciliation is failed, now the court needs to take up the matter and decide upon the dispute or adjudicate upon the dispute. Whereas a mediator does not have a power to make a reference. It can only and only facilitate the dispute between the parties, and if the mediation fails, the mediation fails. So the report that goes to any court, if it's a court facilitated or a statute facilitated mediation, would only be that the mediation has failed. There would be no observation on what actually transpired in the mediation. Whereas if you see the Industrial Disputes Act, if you see the Arbitration Act, a conciliator or a person who is appointed to conciliate your matter would have the power to go ahead and give a pending reference to a court, especially in industrial disputes, where the matter then progresses to a proper labor court or to an industrial tribunal. So that's the difference between mediation and conciliation. Coming to the next and the most opted, unfortunately, that's the most opted alternate dispute resolution, which is arbitration. So when I speak about arbitration, basically people see in arbitration the best of both worlds. You get party autonomy and you have the entire process of adjudication also associated with you. So that fighting spirit in you is still there, but it is outside the court. So you feel that okay, chalo court to nahi jana padta, but the point is, come on, I have some degree of control to tell the arbitrator that this would be the process. So party autonomy is something which is the most important thing why people adopt arbitration. They also adopt arbitration because it is associated with a shorter period of time. And with the 2019 amendment, the arbitrators of the arbitral tribunal only has 1 year from the parties filing their pleadings to adjudicate upon the matter, which can be extended with consent for a period of 6 months. So arbitration, basically, if I would have to define it, is a quasi-judicial process which does not have the rigors of the Civil Procedure Code or the Evidence Act, but stems from them. So it doesn't mean that in an arbitration you wouldn't produce evidence. You will produce evidence, but it might not be as rigorous as the processes of CPC or as the processes of the Evidence Act. And therefore, arbitration is an opted choice for people. You will see every commercial contract having arbitration as the dispute resolution mechanism. In fact, people opt for two methods of alternate dispute resolution. You must have heard of neg-arb, med-arb, conciliation-arb. So the first step becomes to have a more informal process in which parties would attempt to negotiate. Then if that fails, the parties go to arbitration. So people want to balance it out. People are realizing there is awareness. People have learned from their mistakes in the past. Probably they might have seen legacy matters in their own families, where in legacy they don't get the inheritance, but they get legal matters which they have to fight. And it keeps on going from one generation to the other. And to avoid this, you have these different kinds of alternate dispute resolution mechanisms. So, yeah, that's in sum and substance.
Thank you so much, ma'am, there for brilliantly and beautifully elaborating on different kinds and types of alternate dispute resolution. Now, ma'am, in a nutshell, if you could differentiate between all of them.
So, as I just said, that negotiation is usually party face-to-face negotiation. Mediation, it has to be usually with a mediator who is a trained facilitated mediator, an empaneled mediator, or people also want retired justices of the High Court and the Supreme Court to sit and mediate matters. So mediation is facilitated through a mediator, where parties get solutions through the mediator, and after that, if the solution is arrived at between the parties, if there is consensus ad idem, you draw a mediation agreement, you draw a settlement agreement or consent terms, and you move forward with mediation, and both parties lose a little, both parties gain a little. So that's mediation. Conciliation, as I told you, usually in India it is statutory. All right, it flows only out of the statute. Usually people do not opt for conciliation easily, because conciliation in the end gives powers to a conciliator to make references, and therefore only if it comes your way in terms of statutory provisions, like in an industrial dispute, or mentioning of conciliation matters under the Arbitration and Conciliation Act. So the full segment of revolving upon having a conciliation agreement in your commercial contracts, we usually do not see that. People directly go for arbitration, because in the end, if it has to be adjudicated, they want to get it adjudicated in a proper way. So conciliation also has a person who is trained, who would provide solutions, but in the end, if the result is a failure, then in that sense the conciliator would have the power as per the statute to go ahead and make a reference. And arbitration, as I said, in India is governed under the Indian Arbitration and Conciliation Act 1996. Domestic arbitrations are governed under this act, and in order to go ahead and utilize the provisions of the Arbitration Act, parties need to have an arbitration agreement. In that arbitration agreement, you agree to have your disputes resolved through arbitration. You agree to a definite process. You agree to a place of arbitration. You agree to the language of arbitration. You agree before whom you will go and arbitrate this matter. Either it is a sole arbitrator or an arbitrator empaneled by 3 arbitrators or 5 arbitrators. And that's how your arbitration kicks in. When there's a dispute, you will invoke your arbitration clause, and you will go ahead and take the process of arbitration by forming the arbitral tribunal.
All right, ma'am. Going ahead, how do these processes benefit clients? If you could elaborate on the advantages of ADR.
Yes, so the advantages of ADR are twofold. Not only does it benefit the client, every matter solved or referred to an alternate dispute resolution mechanism is a matter less before the judicial courts in India. And therefore, the first and the most important of all reasons to have and to create awareness of alternate dispute resolution is that you will reduce the burden on courts. As I said at the start, the stats are ever increasing. It is a very, very scary situation where the judicial system is being overburdened with many a times disputes which can be resolved over talks. And therefore, the first advantage is reducing the backlog. The second advantage is it is cost effective. So what would you have to pay if you have to do negotiation? You would have to pay your clients for settling the matter, nothing more than that, nothing less than that, and that also would be fees with respect to initiating negotiating talks, drafting settlement agreements, so on and so forth. Secondly, it is cost effective, it is time effective. You will run into cases for years, as I said, that it has to be listed, it has to be heard, there is backlog in a day, there are hundreds of matters in a court, there is so much that a judge can also do. After all, he's a human being. You can't ask him to solve 500 matters in a day, 600 matters in a day, just because there is backlog. Therefore, it is also time effective. For example, negotiation, you'll have 3 meetings, 4 meetings, 5 meetings, and you will arrive at some place where you want to go ahead and settle it. In a mediation, it would be time bound as per the agreement between the parties. When it is drawn up, the intention to mediate, the facilitator would give in certain time. It could be 2 months, it could be 3 months, it could be 1 month, it could be 4 sessions, 3 sessions, whatever the parties decide to attempt to mediate the matter and settle it. In conciliation proceedings, it would usually go by the statute. Otherwise, it would go by the conciliation agreement that is there between the parties. But yes, all of this is going to be way, way faster than what the courts would actually do, because there is a step by step process. There are formalities that you need to do. You need to do filing, you need to issue notices, the court needs to issue summons, they have to appear, they have to file their representation, they have to file a reply, you have to rejoin, they have to file evidence, you have to file evidence, there has to be oral examination. So there has to be a proper trial, basically, right? And what the alternate dispute resolution mechanism attempts to do is take away those rigors and provide you flexibility, where you control how, when, where it's going to be for you, and have a result probably in a definite period of time that both parties have agreed to. And let me tell you, it is worth every moment that you spend here. It cannot be waste, because it will be 3 months, but at least it will not be 3 years, it will not be 4 years, it will not be endless years where you are waiting in courts to get a decision or to get away with a decision. Either way. So that's about mediation and conciliation. When it comes to arbitration, as I said, under the 2019 Act, there is a 1 year mandatory period in which your arbitration submitted under the new Act has to be undertaken within a period of 1 year. 6 months have been given to both parties to file their pleadings. Post that, within a year, the entire matter has to be heard by the arbitral tribunal and has to be decided. If at all, for supervening circumstances, parties want to take time, then there is a 6 month extension, but both parties have to consent to that extension. Beyond that, if the arbitrator fails to pass an award or the arbitration is not concluded, you have to go to the appropriate court to get an extension. Otherwise, the arbitrator will have to recluse himself from the seat. So it is time effective, of course, cost effective. Anytime it is cost effective, but these days arbitration proceedings are actually becoming a little away from the concept of cost effective, because if you have, for example, 5 arbitrators, then you have to pay fees for 5 arbitrators rather than just paying the court fees. So at times arbitrations become cumbersome in terms of the cost effective principle, and to get that into picture, the 2019 amendment has now put in a schedule of fees that the arbitrators can charge. So it depends upon the claim, and a calculation is given to see that the fees of the arbitrators is not as per their whims and fancies, but is, brought into the purview of the statute to cover that up, where it sticks to the principle of being cost effective. So that is a welcome move, where you have a statutory limitation to the arbitration fees also. Otherwise, the purpose of going to arbitration, really becomes worthless. If for every sitting I have to pay 5 arbitrators the fees they quote me without any justification, it's going to be cumbersome. And so many a times people really don't want to have arbitration clauses and want to go to the civil process, because what would they have to pay? They would have to pay court fees, they would have to pay lawyer fees. Lawyer fees they will anyways pay in an arbitration proceeding also, because there also they want to be assisted by lawyers. So therefore, to bring in that cost effective benefit, the statute has now brought in the schedule wherein the fees is calculated as per the claims and the counterclaims filed by the parties in the arbitration. So just to revise, it reduces the backlog, it is cost effective, it is time effective, it does not consume a lot of time. It is definitely better strategy wise, wherein you come up with offbeat ideas, and it gives you a lot of flexibility. All the processes of alternate dispute resolution will give you flexibility, will give you certain degree of control to want to have things in a certain fashion, which is what you will not get in a regular dispute resolution before a court, because you have to abide by the procedures, you have to abide by the evidence, you have to abide by what the court decides is appropriate as per the court rules. So according to me, these are the five most important gems of going to alternate dispute resolution mechanism.
Thank you so much, ma'am. There. Next question. Now, talking about the provisions of the Commercial Courts Act 2015, there is a mandatory pre-institution mediation, which is specifically stipulated as a provision. Ma'am, if you could shed some light and share your views on it.
So, while we are speaking about mandatory mediation, as you stated at the start, I would really want to recollect with many other laws that have this insertion of mediation, and it's a very recent thing. If you would see, it's not something that has happened since the alternate dispute resolution mechanism concept, or something which has happened after section 89 of the CPC, which provides for alternate dispute resolution mechanism to come into the picture, okay, by saying that any court, if it feels that there is a possibility to settle the matter, or there is a possibility to adjudicate this matter in a better fashion, may sort of refer the parties to an alternate process, whether it be mediation, it be the lok adalat, it be arbitration. So section 89 in the year, I think 1997, when the amendment was made after the Law Commission report, that the cases are increasing, dispute resolution mechanism has to be boosted through alternate dispute resolutions, where people get the opportunity, even if they are before courts, they can go ahead and explore a possibility of settlement. And if that is submitted to the court, or if the court suo moto feels that why don't you settle the matter, I mean, so many times when we are there in court, we will see that families, brothers, father, son, mother, daughter are before the court, fighting over things and having endless litigations, where the court finds itself in a sorry situation to see a family breakup because of XYZ reasons. And it is then where the court itself would suggest, listen, you are blood relations, why don't you go and mediate the matter? And that's what makes the pathway, that's what gives the courts also that freedom to get in alternate dispute resolution mechanism where they feel it would be a necessary thing. Now, just because the court has sent me under section 89 of the CPC, that does not really mean that I have to settle my matter through mediation, or through the lok adalat, or through arbitration. So it's my consent to. If I say no, or if one party says no, you can't really explore a section 89. And even if both parties go, it doesn't mean that you can't come back to the same court. So the court does not dispose of the matter. The court will basically stay the matter, keep it in abeyance, and keep it for the report of the lok adalat, keep it for the report of the mediator, or keep it for the report of the arbitrator to say that it has accepted reference to the arbitration. That reference is then filed before the court, and it is only then, when the matter is disposed of in the light of such settlement, in the light of such report, or in the light of a reference to arbitration accepted by the arbitrator. So this was what happened in 1997. After that, there is absolute silence. For many years, people don't realize that you could explore the true strength of section 89. Simultaneously, in the year 1996, the Arbitration and Conciliation Act that is there has another section called as section 8 of the Arbitration and Conciliation Act, where either party to the arbitration, and basically either party to a suit pending before a judicial court or a judicial authority, can file a section 8 application, usually being the defendants, because if a petitioner or a plaintiff has filed a suit, it definitely does not want to go into arbitration. But a defendant who feels that there's a possibility for arbitration, and there is an arbitration existing between both the parties, can file a Section 8 under the Arbitration Act and can tell the court, look here, there is this provision there, there is a valid arbitration agreement, kindly refer us to arbitration. But the powers of the judicial court under Section 8 are much, much wider than a Section 89 of the CPC, wherein they can also go a step further to see if the subject matter of the dispute before the court is a dispute which can be arbitrated in a private forum such as an arbitral tribunal. And if the court feels it can't, then it has all the power to reject the Section 8 application. So these were the initial two boundaries which could take away a post litigation into an alternate dispute resolution mechanism. Now, while we had post litigation mechanisms, we did not have pre litigation mechanisms. So now the courts and the law commission started churning alternate dispute resolution mechanism a step further, and they have introduced these welcome provisions in the Commercial Courts Act. So the Commercial Courts Act basically came in 2015, okay, to reduce the burden of suits that were being filed and taking a special chunk of commercial suits to specific courts with a specific pecuniary jurisdiction. Then they realized, oh, people are really coming and flooding commercial courts under the Commercial Courts Act. What is to be done? Everybody is running and filing these commercial applications, commercial IP suits, commercial arbitration applications. What is happening? And at that point in time, they came up with this amendment in 2018, which said that look here, before you come to us, please go and have a pre mediation, a pre litigation mandatory mediation. And thus in 2018, this whole segment of inclusion of a mandatory mediation came into picture. But the and only um, exception to this is that if you have a urgent relief that you are seeking and you can't wait to mediate a matter where the stakes are high, where you feel that parties would, render the whole purpose of filing this suit worthless, would do away with evidence, would tamper with things, would alienate with property, you have to go and file that interim application for urgent reliefs, and that's when you can skip mediation. But if the court feels that there's nothing urgent, they will send you back and tell you go first mediate the matter, then come to us. So that's the whole idea of having this pre-litigation mediation. Sorry, I'm just getting confused. So pre-litigation mediation. And the words mandatory, though used, as I told you, it is not mandatory for you to settle it there. Again, if you fail to settle it there, you will come back to the court. The court will keep that in abeyance. A similar process you will also see in the MSMED Act, which is the Micro, Small, Medium Enterprises Act, which is a special act made for these special companies, okay, which are registered and which have an MSME license. So there also the step is this, that you have a mediation. First, you'll have a mediation. So you have to file a notice. You have to give a demand notice under the MSMED. After that, you will have a mediation notice come from the MSMED. If the mediation fails or if you don't participate in this mediation, it will go to arbitration under the MSMED. So that's a Med-Arb process. So you have a mandatory mediation there also. So that's one part which has mandatory mediation. Then yes, as you rightly said, the Consumer Protection Act in 2019. This is an act which has been, amended a lot within the past 2 to 3 years, and now, getting all the technology and digital variants also to the consumer protection is a welcome move. And they have also, inserted that there has to be a pre-mediation to all the consumer litigations, and the exception there also remains urgent interim reliefs, where you can come and show your urgency and be exempted from mediation. So the Consumer Protection Act has also come up with this. As you rightly said, the Companies Act has also made a path breaking segment in section 442, wherein they have also made a provision for a mandatory mediation if the NCLT or the NCLAT or the central government feel that a dispute between the parties can be resolved through mediation. It will be referred through to mediation under 442 of the Companies Act. Now, one thing that I must emphasize, and the most important role played in mediating matters is also by the Lok Adalats in India today. So the Lok Adalats have been established under the Legal Services Authorities Act much before any of your section 89 or your section 8 could have come into picture. I think it's 1987 around when this act had come into picture, and the inclusion of Lok Adalats. So Lok Adalats are these small courts which take up small matters which are not exceeding rupees 10 lakhs. So you have different kind of Lok Adalats. In fact, recently there are mobile Lok Adalats also, which come up at certain periods in certain jurisdictions, wherein certain matters by the courts are referred to these Lok Adalats. Then you have, of course, your permanent Lok Adalats, your national Lok Adalat, and the stats are so glaringly effective. Like, people might be saying that Lok Adalats are not effective, but if you see the statistics in the past 3 years, the national Lok Adalat has solved almost 81 lakh 55,000 cases, and the permanent Lok Adalats have resolved around 20 lakh cases. So that makes 1 crore cases, which could have been before the judicial systems. Today, if you see, it is quite a high number. You have 4.4 crore cases. You have 1 crore cases probably that you are resolving through Lok Adalats. And you're saving the courts from so much of rigors. You're saving yourself from so much of rigors. So Lok Adalats, it's a fantastic platform, according to me, for smaller matters up to about 10 lakh rupees, which do not have high stakes, and people can go there. In fact, 89 of the CPC would also kick in matters being sent to Lok Adalat. So that's a good development, according to me. It's a successful development, according to me. And if it is promoted in a better fashion, if I think the pecuniary jurisdiction is increased to maybe 25 lakhs, 30 lakhs, where permanent Lok Adalats could really mediate and adjudicate upon such matters, I think they could do more justice to the strength that they show today in India. So that's about the inclusion of mediation in different statutes, and how the legislature in India today is really thinking from all angles to see that mediation is explored as the most effective uh, dispute resolution mechanism, because it's got very less rigors on cost and high flexibility and high effectiveness in terms of time and turnaround.
Ma'am, talking about Lok Adalats, do you think that they've proven to be successful in India, or you think that they failed to achieve the objectives?
According to me, I really can't complain, because when I am seeing the stats myself, I am really shocked. When I read about it recently, I think somewhere in an article that came up in Economic Times, maybe just 3-4 months ago or 5 months ago, I can't recall. I was really amazed by the fact that if the Lok Adalats have the strength of resolving 1 crore matters in about 2 to 3 years, I really can't complain that they are not staying true to their objectives. They are, in fact, and they are doing a good job. And according to me, if you increase their pecuniary jurisdiction, they could do probably much more cases. They are now bound by a pecuniary jurisdiction. They can't take other matters. So let people go and explore that. Double up the jurisdiction. You will really help the justice system with this. So I'm pretty floored by the stats.
So, moving forward now, Ma'am, we all are in the middle of a pandemic. So, talking about arbitration in pre-COVID, during COVID, and post-COVID times, if you would share your views, will things change? Will the whole system of how arbitration functions in India change to the virtual hybrid?
According, according to me, the pandemic has really given everybody a test drive of technology. Everybody was on paper. Today, everybody is paperless. I mean, I'm sure if you're in Rajasthan, I'm in Bombay, this virtual amicus could probably not be there if hadn't it been this online convenience that we are having. And the new term of ADR today and arbitration basically today has turned into ODR, which is online dispute resolution mechanism. That's a new trend where COVID has basically let us understand the potential of what we could do with technology. And today, with the pandemic, everything has swiftly turned on to technology. You're arguing matters not only arbitration. Take up the entire judicial system in India. Nobody would have thought that a council could sit here and argue matter in Karnataka, or argue a matter before the Supreme Court of India, right, sitting at his own chamber in a completely different state, or for that matter in a completely different country. So it's absolutely done away with physical presence, which is a welcome move. And that's what has happened in the post COVID era. COVID has done this magical transition, and it's just fabulous. You are sharing evidence, you are arguing swiftly the matters. You do a screen share and everything is before the court. All your pleadings are there. You email the submissions, the court has it. And the transition is welcomed by the bar and the bench. It's just fantastic. And another thing is that you can't really now escape arguments. Like, you have to do them. You can't seek adjournments. You can't seek adjournment saying you could not be physically present. So it's a welcome move. It's just rolling the ball to no nonsense, no time taking business. You have to do it, means you have to do it. Arbitration is moving swiftly all across the globe. In fact, you see the ICC rules that are there. They have these transitions now where they are saying that all the hearings will happen through virtual hearings. So alternate dispute resolution mechanism is the key, whichever mode of dispute resolution you take. In fact, remove ADR. Any dispute resolution today is wonderfully working in the systems of data and technology. And COVID, thanks to COVID for that. If there's one positive factor that we should take from coronavirus, it's telling them thank you for really removing the stigma of taking matters online. And the courts have recently appreciated that this should be a regular process before all courts. So,
Thank you so much, ma'am. There. So, we all are aware that the ADR regulatory mechanism in India is plagued with a lot of problems.
just give me 1 minute, huh?
Sure, sure. Please, please.
Uh,
No problem. So, we all are aware that the ADR regulatory mechanism is plagued with a lot of problems. If you could give your views or share your views on that. What are these problems
yeah. So
that we're facing?
So, one big problem is the stigma. People still do not have faith in your alternate dispute resolution mechanisms like they would have faith in the court procedures. The reason why is the verdict has the power. So, so it becomes easy to breach a mediation. It becomes easy to commit in a negotiation and get away with it. But you can't get away with the court order. You know, You have that fear that if I don't follow the order of the court, I have got other things coming my way. I have got contempt proceedings coming my way. I have got damages that would come my way. And therefore, the alternate dispute resolution mechanism, even though having so many advantages, takes a backseat because people can get away with it. The seriousness to the alternate dispute resolution mechanism does not exist today. And that's why I feel that there has to be certain statutory power or a stigma or a deterrence given that if you fail to accept an offer and you come to court and you fail to establish your case, then you should be penalized. You should be given damages. You should be given the entire cost of conducting this arbitration or conducting this suit or conducting any other complaint or any other application which is filed, for wasting the time of the court, for wasting the time of the other party, for wasting the resources, for wasting the opportunity that was already granted to you at the start. So, where matters can be negotiated, where matters can be mediated, where matters can be resolved through alternate dispute resolution mechanism, if you do not explore them or you reject them for baseless, frivolous reasons, then if you do not succeed in your case, there has to be deterrence. So, one is deterrence, and two is seriousness. These are the two things that actually take back the benefits that an alternate dispute resolution mechanism could really unfold.
Thank you, ma'am. There.
So basically, people call alternate disputes a teethless body,
Yeah.
except for arbitration because you really have an award, but that also then goes into challenge before the court. So from an alternate dispute, you go into the actual dispute.
So it's back to square one
So,
ultimately.
so it's back to square one. Then you have your section 34 of the arbitration. Then you have your section 37. Then you go to the Supreme Court, file a special leave petition. So it's
Luxury
back
for
to square
lawyers
one.
and pain for the clients.
Yeah. Truly, truly. Lawyers, in fact, lawyers should also give that awareness. It plays a very important role. Lawyers play a very important role in guiding their clients to the right path. So that's where also probably we as lawyers are lacking because we want mandates at times, and that's not correct. We should see the better interest of the clients as well, and if a matter can be well settled in alternate disputes, we should go ahead and advise the client that way.
Yes, ma'am. So, moving forward, to all the young lawyers and law students who are watching this, ma'am, how does one build a career in A.D.R. practice, alternate dispute resolution practice? So, any internships or courses that you would recommend to law students or young lawyers who are watching this?
So I am also quite a young lawyer right now, but yes, in fact, I have spent around 8.5 years in the commercial side of as you know, Jay, in the commercial side of this industry, which also includes alternate dispute resolution mechanisms. And my mentors and my seniors with whom I'm working have told me, and I completely understand and reiterate why they say that, is that there is no alternate dispute resolution mechanism when it comes for you to practice. You have to be a disputes lawyer. And the reason why they say that to us, and I completely relate with it, is that you can't be a person who can effectively explore alternate dispute resolution mechanisms unless and until you know your laws. So, dispute resolution mechanisms which are presently existing, the laws that govern those dispute resolutions, you need to know it all. The reason being is that you can't really, as I said, effectively mediate a matter. You can't effectively negotiate a matter. You can't effectively represent your client in an arbitration if you do not understand the underlying dispute. And that's where, to be a successful ADR lawyer, you need to be a hardworking, determined, and a successful disputes lawyer, knowing your civil commercial laws in and out. And therefore, all the budding lawyers, to explore their fullest potential, should know their basic commercial laws, wherein they can be the person who can work out of the box, who can negotiate better, who can facilitate a mediation better, and who can represent in an arbitration to its fullest potential. So that's one advice that I would want to give. And prior to joining any courses, read your bare acts. Read, and read. That's the mantra to be a successful budding lawyer.
And lastly, ma'am, if you could share your experiences or lessons that you've learned as we conclude our segment.
Lessons that I have learned: there is no easy way out. In your initial years, you have to struggle. You have to give that cutting edge to yourself. And in order to be a person who can materially assist a client, you need to be determined, you need to be focused, and you need to not alienate yourself by picking up a specific field only. Explore, be determined, be focused. That is what I have sort of learned from my experiences, and this would only help you go forward and embrace challenges. And that's the real motivation, that how far you can independently assist a client without a senior's help, or how far you can go ahead and give your team an idea which they did not think about. That's when you have started to truly uncover your potential. And each person today, no matter which field of law you want to practice ahead, should understand that at this stage where you are starting your field, to explore yourself is the best opportunity, and it's the best way to move forward.
Thank you so much, ma'am, for your valuable insights on a very important topic, alternative dispute resolution. I'm sure this segment will immensely benefit all the viewers who are watching this. So, thank you so much, ma'am, once again. To all the viewers, stay tuned. Next episode is on its way. The email is mentioned on our channel. So, if you still have any queries, which I'm sure you will not after this impeccable discourse, after this brilliant presentation, you can still mail all your queries to our shoot or emails. We'll be more than happy to forward the same to our amicus for today's session. And thank you, ma'am, once again for your valuable insights. And
Thank you, Jay. It's been wonderful. Keep doing what you are doing. I'm sure this is helping all of us in learning something new every day. You know, you can't really, as a lawyer, say you know all the 1,010 statutes that are present today. You know, everything has an act. You might not know it, but it exists. So, so, and also ignorance of law is no excuse.
yes,
So, you know, you are helping people know better each day. And I'm really, really impressed with the work you're doing. Thank you so much for having me. Thank you, everyone who will be watching this session. I hope you will like it and you'll enjoy it.
thank you so much, ma'am.
Bye.
We all are students of law, and we hope to learn as much as I can from each other.
Yes, yes, absolutely. Completely agree with that.
Thank you so
Thank
much.
you. Bye,
Appreciate it.
Jay.
Bye bye. Take care.